okay.
Mr. Curtin?
Thank you, Your Honor. Kevin Curtin, Assistant District Attorney from Middlesex on behalf of the Commonwealth.
Now, the two characters involved here have pled guilty, have they not? The defendant and the witness?
Yes.
At least that's a note I got on the docket here.
Right, that appears, the defendant has not pled guilty, the witness has pled guilty, the defendant has been indicted as a youthful offender.
The adult defendant
The adult defendant.
pled guilty, yes.
Well,
Didn't he?
no, it's just an error.
Wait, I'm sorry.
They're both treated as youthful offenders and therefore available.
No, but there was 4 people to start with. Am I right about that? 2 adults, 2 youthful offenders?
Right.
I guess that's right.
So,
The,
somewhere in the adult proceedings, somebody pled guilty, I think. No?
I'm not sure that is true.
I think it is.
Is that right?
I think it is, yes.
I'm sorry that I had that wrong. The point about the important thing with respect to that note in the docket is that the materials are available to the public in the same way that they would be with respect to what
Okay, but I guess I was getting at whether there's a mootness problem of any sort because of the guilty pleas of the witness.
I don't think so,
there's-
because
no,
the other youthful offender has not pled guilty, or pled.
And it's in that youthful offender's case that you brought this motion in limine, is that correct?
That is correct.
So there was a case pending in the juvenile court
Right.
in which you seek to have the immunity order enforced.
Correct.
And that case is still pending.
And if
That
that's
case
still...
is still pending.
So
Okay.
so it's not moot.
Right,
It's
all
certainly
right.
not moot.
okay, that's fine.
And there's nothing wrong with making the materials available with respect to the youthful offender files either,
Mr.
even though that
Curtin,
case is still open. That was my concern.
yeah, Mr. Curtin, could you just elaborate for me, page 3 of your brief, you say, on August 9, the Commonwealth moved in limine for a ruling that the juvenile court would honor the immunity order. Was that in the case, was the case against the youthful offender heading towards trial?
Yes,
So,
It was.
so that was a motion in limine, a standard pre-trial
that's right.
motion in limine beforehand.
That's true.
Okay.
That's right. And
What we
that-
got here is inconsistent rulings by juvenile court judges, as I understand it.
No, you
No,
just have,
no.
no, you just have Blitzman.
Well, we've got Blitzman saying you can't do it. I thought we had another decision.
Single justice decision.
Single justice decision,
single
from
justice-
somewhere
the single
saying you could
justice-
do it.
That's correct.
Okay.
The single
Well, we
justice,
got conflicting decisions of some sort.
that's right. And this is another opportunity to clarify that where there is a criminal proceeding pending against an adult co-defendant, at least, that
I was the single justice who reserved and reported this case. I did not decide it unless
no,
some
you
other
did
single
not.
justice
That's a
decided
separate
it.
single justice case. That's the
There's
Kearns
another
case.
single justice.
Oh, in
That's
the
the
Kearns
Kearns
case.
Kearns.
Oh,
Appears
Kearns.
on pages 36 to 43 of the record appendix. That's
Well,
the,
Let me ask you this. The way the statute used to be, when the immunity was granted by the Supreme Judicial Court, the justice up here would grant the immunity, and then it would apply statewide. There was never any issue. Nobody ever said, well, it doesn't apply in this court because the SJC granted it. And isn't it the exact same here, except that the statute was amended to
it is.
give the authority to judges of the Superior Court and elsewhere authority to immunize, but it didn't limit it to the Superior Court or anywhere else.
It's absolutely right, and that's exactly how the case comes out. It's an order of full transactional immunity. It stays with the witness. There's no limitation on that order. It has to be fully coextensive with constitutional protections.
Otherwise, it makes no sense.
Right.
That's
I mean, it
precisely
means
right.
somebody who's in a juvenile court gets some kind of benefit that he wouldn't get if he was
Well,
anywhere
no,
else.
he wouldn't get a benefit.
Yes,
Sure,
if
because
you...
the witness wouldn't
right.
testify.
And
I'm
even
sorry.
stranger
right.
than that would be if we didn't interpret the law the way you say, someone who's been immunized in the Superior Court would then go and decide to testify in juvenile court and then could be prosecuted for his testimony in juvenile court because he wasn't immunized there, if you follow the defense argument to its
exactly
logical
right.
extension.
That's exactly right. That's how the case, I mean, our statute, an order of immunity under our statute must be fully coextensive. It can't be effective in Alaska or in Guam, but not down the street in Lowell Juvenile Court.
Doesn't the confusion come up, and I've got to get the
the provision in front of me, but it talks about it will be you can't suffer any forfeiture or as a result of this testimony, but then talks specifically about testimony in the superior or district court, or
It says in that proceeding, I think that's where it's...
You're speaking to the language of...
in the statute.
There's section 20C or 20E?
Let me find
There's
it.
language in a criminal case in both 20C and 20E, and the purported limitation upon the efficacy of a grant of transactional immunity is to be found in the language in 20E, proceeding in the or the criminal proceeding in the Supreme Judicial Court, Appeals Court, or Superior Court.
Right. I mean, I'm not saying it just, but that's where the confusion comes out, from.
I think you're right. It seems to come from there. And the dicta that is in the Russ R. case, which was just about whether a juvenile court was authorized in the first instance, addresses that issue. And that's not our case. The court has not yet had a case.
You're talking about the language that says, the plain language of the statute, after they talk about the to grant immunity to a witness scheduled to testify in a proceeding conducted in...
The statutory language of 20, yes.
Yeah.
In
It
a
does
criminal
not
proceeding.
permit a justice of any court, including this one, to grant immunity to a witness scheduled to testify in a proceeding conducted in the juvenile or district court.
Scheduled to testify, yes. That type of language, that's from you're looking at Russ R., the paragraph beginning.
222, yeah.
Yes,
Further.
the authority to grant is delineated by.
Yeah.
That's problematic if read too broadly, yes.
But that was only addressing whether the judge of the juvenile court could grant immunity.
Correct.
That was the issue in that case.
That was what the case was about. And that language is just dicta about that. Here's an opportunity to be helpful about the constitutional sufficiency of an order of immunity.
How do you deal with the scheduled to test? I take it it's the scheduled to testify in a proceeding in the Supreme Judicial Court, Appeals Court, or Superior Court.
Yes.
In this case, the witness was scheduled to testify, correct?
That's true.
In the Superior.
In the
Absolutely.
Superior.
That's
And
right.
that's when immunity was granted.
And that's
That's
when
true.
immunity was granted.
So under that dicta, we're fine,
I
because there are
think so.
parallel proceedings in
the
Superior
I
Court.
think so. Right?
But what if there wasn't a proceeding in the Superior Court, and you would have to go to the Superior Court or the Appeals Court or the Supreme Judicial Court to get immunity,
Well, you
and
might
then you would have to use it in another court?
Well, you might not be
That's
able
right.
to do that if there were no proceeding. That's not this case.
Precisely.
And that's
the
what
argument.
Justice Ireland was concerned about in his concurrence, I think, or
Yes, that's
dissent.
right.
Which is
That's
to
right.
say, if you don't have two defendants, if you only have one youthful offender, if you only have one youthful offender in the juvenile court,
Yes.
you can't go to the Superior Court if the testimony is going to be in the juvenile court and get a Superior Court judge to grant immunity, correct?
That would be that argument.
Yes. So that maybe needs to be addressed by
yes,
the
it
legislature,
does.
but that's not this case.
It's not.
There was
but
a
you can-
proceeding in the Superior Court, there was a witness called to
Exactly.
testify, the witness took the Fifth Amendment, or said he was going to take the Fifth Amendment, and immunity was granted in connection with his soon-to-be testimony
Yes.
in the Superior Court.
No, well, in connection to the transaction, the full.
No, I understand that,
Yes.
but it was because he was going to testify in the Superior Court.
I take it that Judge Blitzman didn't think he had the authority.
Yes.
That was it. He said this. He said, "This court cannot extend and apply in the juvenile court a Superior Court's order granting immunity to a witness in a pending Superior Court matter."
Yes.
So he didn't think a juvenile judge has the authority.
Exactly right.
Let me ask you this. Under the youthful offender proceedings, you go to the grand jury, am I correct?
That's correct.
So if you do, then could you interpret 20E, since then there'd be an investigation or proceeding before the grand jury, you'd have to do it at that time, go and get immunity. And then when it's in the juvenile court, you'd already have your immunity order.
Well, that
You-
may not,
If you did it at that time, then the immunity would be effective everywhere. If you did it later, it would also be effective everywhere. But the defendant's argument is that it's somehow limited.
no,
to-
but you
No, I'm
have to
talking-
know where the person was scheduled to testify.
That's
he
only
was
the
scheduled
language
to
of our
testify
side. That's
before the
not
grand
language of
jury.
the statute.
Well, if he was scheduled to testify before the grand jury, that would be a basis on which to get the immunity order, and your argument is,
that's right.
once the immunity
And then
order
you'd
is
have it.
obtained,
That's absolutely
So
right.
maybe that's your way around the problem when there is only a proceeding in the juvenile court. You better go before the grand jury to get
Except
the...
that you would, I mean,
Immunity
it's,
Well, we would have to sort of convene or have the grand jury investigate a matter that's pending in juvenile court, and it would seem to be a little bit
No,
cumbersome.
the youthful, I'm talking about youthful offender.
A
You go
youthful
before the grand
offender is
jury
our-
Anyway.
Well, you could, I guess that's possibly right, but
Mr.
at
Curtin,
that
may I
point, the youthful
suggest we
offenders
don't
would
have that case?
Yeah, that's right.
So,
That-
I
okay.
don't know,
I
we don't
agree.
have to go into whether the statute would or wouldn't permit it.
It'll be another case.
That'll
and
be
I would
another
argue
case,
that
and
in
may
such-
be quite problematic.
And maybe the
It's hard
statute
to
will be
imagine.
amended. Right.
It's hard to imagine that we couldn't come to this court, or a single justice of this court, and seek immunity with respect to testimony that's going to take place only in juvenile court or only in district court, rather than relying on a prosecutorial letter. But we don't have that case yet. In this
Well, it's
case,
questionable whether one could do it, unless the proceeding was going to be, as the statute provides, with the immunity that was scheduled to testify in a criminal proceeding in the Supreme Judicial Court, Appeals Court, or Superior Court. So if it was clear that the proceeding was not going to take place in the Superior Court, there would be a problem, potential problem. But that's not our issue today, correct?
that's right.
Here, the witness was scheduled to testify in the Superior Court, and a Superior Court judge granted the witness immunity.
That's absolutely right.
Full transactional immunity.
Full transactional immunity. It's the witness's right. It doesn't disappear once the witness walks into a juvenile session. And that's the way to analyze the issue, just as was done by the single justice in the Kearns case. And in that case, similarly to here, there was a parallel adult proceeding, and that's the way to start. You start with the constitutional issue. Everyone has, the people have the right to everyone's testimony unless there is some kind of a privilege. If there is no privilege, then there is no right to refuse to testify. And then the issue...
Did I do Kearns? Who did Kearns?
No, that was
Justice
Justice
Sossman.
Sossman.
Oh, that's right, Sossman.
And that is part of the record. The reasoning of the single justice is salutary, and I would recommend it to the court, because I think that is the way to approach these types of issues. If you get stuck up with the statutory language and try to think that somehow or other the statutory language, if viewed in some kind of a narrow way or some limiting way, detracts from a grant of transactional immunity, that way is the way towards error. And what you want to do is to start with the constitutional protection that the witness expects and must receive as a matter of Article 12 for it to be effective. And that's really the beginning and the end of that issue in this case. The next issue has to do with what happens in the juvenile court where there is no privilege to refuse to testify, and the witness nonetheless asserts that he won't testify. And I would submit that at that point the judge should simply inquire, as due process would require, whether he understands that he has been granted full transactional immunity, and that if he does not testify, that he may be subject to incarceration, and that can be held in contempt if he refuses. And then third, that could lead to incarceration. And the mechanism for addressing that type of a civil-type contempt, which calls for a term of incarceration up to a year, or until the contempt is purged, is found under 20E, which would allow the judge flexibility to either conduct a summary-type process, a hearing or trial is the language of 20H, and that's the appropriate way to deal with that issue. It allows the trial judge before whom the contempt occurs, the contempt is not answering the question, then the appropriate flexibility to determine whether it can be handled summarily or whether a fuller trial is appropriate.
Is
Steinberg.
that question a hypothetical because that hasn't happened yet?
It is. It has not happened, and it's possible that the witness might not refuse to testify.
Well, why do we have
So
to
why-
answer it?
why would
Why
we
do we have to
You
address
don't,
it?
you don't need to decide that in order to decide the case.
Don't you actually,
But the entire case was reserved and reported, and that was raised in our request to honor.
Mr. Curtin, don't you have the similar problem, though, under 20H? Because it says that if a witness has been granted immunity and refuses to testify after being so ordered by such justice, that is, a justice of the Supreme Judicial Court, Appeals Court, or Superior Court, so it's not that Judge Fishman ordered him to testify. It would have been Judge.
Well, I think that's not right, Your Honor.
We
The
don't-
order is part of the immunity order, that Justice Fishman ordered
That
that
he
he
answer
answer
questions.
questions
Oh,
relative
okay.
to the transaction.
In any, okay, I'm sorry. You're right.
That's order, that's the 20E order. The trial judge doesn't have to order to testify, he has to simply do what due process requires before,
Okay.
I would
I
suggest.
see what you're saying.
Thank you.
Thank you. Mr. Smith?
Good morning. May it please the Court, and Happy New Year. We are splitting our time. I represent Navon L., who is the defendant in this matter. My sister represents the witness. Were it so simple as just outlined, the difference being Russ R. came in the context of an order from the trial court in that case. It's on page 517 of the Russ R. decision, and that order, wherein the judge denied the Commonwealth's application for immunity, the judge said that 20E limits the authority to immunize witnesses to those criminal proceedings in the Superior Court, within being emphasized. And then, of course, it went up to this court and the Russ R. decision, and I think that the language in Russ R. on page 522 clearly contemplates that it isn't quite so clear-cut, and that there is this issue in terms of, well, does that sort of context of proceedings, does that mean that it has to be, it could only be in a separate proceeding?
No, but how do you, I mean, if you look at the language on 522, which is the, is the language, I mean, here what you do is you have an order granting immunity to a witness scheduled to testify in a criminal proceeding in the Superior Court, correct? That was when the immunity was granted.
Correct.
Then you have John Doe, right? And you have, as Mr. Curtin has said, once you get immunity, it's transactional immunity. It's not immunity for, but this is the same transaction, correct? There's no question.
Correct. But of course, that relates to the scope of the privilege, as it were, of the immunity, I should say.
But
let
it
me-
follows you around because the Commonwealth couldn't, for example, the Commonwealth couldn't prosecute if there was a different if the proceeding ended up in some other court, for example.
But again, of course, the
Mr.
difference here
Smith,
being...
the question is, if you're right, and immunity is granted in Superior Court, and then the witness goes and testifies in the juvenile court, the Commonwealth could prosecute that witness, if what you say is right, could prosecute the witness for what he said in juvenile court, and how can you have such an illogical result?
Well, I mean, that may or may not be the case.
Well, it would be the case. If the witness gets immunity from Judge Fishman in the Superior Court, and then goes and testifies in the juvenile court, doesn't claim the fifth, testifies, and then if that witness didn't have immunity in the juvenile court, the Commonwealth could prosecute the witness.
But again, I think that the language in Russ R. on page 522, it does not limit it to merely what the Commonwealth's position is. I think that the order, the context, the order in which it arose in Russ R., the order from the lower court, I think that clearly that judge was saying that it is not enough for the Commonwealth to get a grant of immunity and then it can be honored in the juvenile court.
I think the term honor is a peculiar word. I mean...
I think it is, and I would also add that the Commonwealth, my brother had used that in his brief, in his reply brief. I see no authority for that concept. Of course, I suppose a lot of times the context would arise would be, for instance, a grant of immunity from another state, and of course the case law is clear that it would have to be recognized by this state. Of course, that's a different premise. It's the full faith and credit clause, that sort of thing. But the difference here is we have Russar, we have a different juvenile system, as I think my sister sort of emphasized in her brief, that it is not so much geared toward.
But how do you answer Justice Cowen's question? You may say that that doesn't arise, but let's assume that enormous pressure is put on a witness to testify. We know that happens, right? And the witness has been granted immunity in the Superior Court and testifies that he did see a knife. I don't know the facts of this case. And he then testifies in the juvenile court that he didn't see a knife.
Correct. But I think
Could
Russar,
the Commonwealth prosecute for perjury?
but Your Honor, I think respectfully, the Russar framework tells us that the remedy for that is vis-a-vis change in the legislature, as opposed to what the Commonwealth is arguing here. And in fairness, of course, it's a difficult thing because there really is no guidance on this.
Well, Mr. Smith, who
conclusively.
could grant immunity in the juvenile court trial?
Well, certainly, Russar tells us no juvenile court could directly grant
Okay,
immunity.
so,
Or any other judge.
So who-
and
so who
to
could-
answer that, if I could answer that question, Your Honor, by something that was discussed here when when my brother was arguing. The old immunity paradigm, yes, indeed, it was simply the SJC that could issue it, no question. However, what my brother had left out in his brief was it only pertained to grand jury proceedings. So it wasn't as if you had this sort of paradigm where the SJC could grant immunity and it was
so
applicable everywhere.
who could authorize it?
Under right now,
Yeah.
I would suggest that there is no such
There's-
But
There's
how,
no
how
way
is
to-
it,
It's an anomaly, and I think that Russar spoke in terms of there being an anomaly.
But then you come
That's
back
not
to the...
common sense, is it?
It might not be, but I would suggest that the remedy is.
And that's
How-
what Russ
how-
says. That's what Russ appears to say. I mean, I agree with you. The language in Russ can certainly be read that. It says directly, the plain language of the statute does not permit a justice of any court to grant immunity to a witness scheduled to testify
But
in a
Mr.
proceeding in the
It
juvenile
puts
court.
those as parenthetical words, but they are there.
Right,
but
so
if
that
you
could
say, if you say that if he has this order for the Superior Court, and the order is very clear that this is transactional immunity to the scope of the constitutional grant of immunity, how is it that that isn't going to be recognized in any court of the, I mean, how,
Well,
it
it
just,
isn't, I'm not suggesting any court certainly would apply.
no, but but how can any court say, I don't recognize that? I
Well,
mean,
again, but we have a. we
It's not a
have sort of-
grant of immunity. Nobody is asking the juvenile judge to grant immunity, right?
But I think the answer to the question is, well, that just means that the person has the privilege in the juvenile court proceedings, right?
has what privilege?
That would be, has the privilege not to testify. If the immunity doesn't extend to that
But
testimony.
of course it does. Because by the statute, you cannot be put to whatever the language is, forfeiture. You can't suffer any forfeiture or penalty as a result of
But
relating to
again,
this.
I would suggest that there is the two questions are separate. The scope of the immunity versus where the immunity would or would not apply. And that is our statutory framework in Massachusetts. It might be unorthodox. There may be this sort of
Nonsensical.
dilemma,
Surely,
but that
but
is what it is.
I guess I didn't make my point very clearly. If we were to conclude that this individual does not have immunity to testify in the juvenile court because no court was empowered to grant it, then of course he still has the privilege.
Raises privilege.
But if we were to conclude that indeed the grant of immunity in connection with a Superior Court proceeding grants immunity broadly, then of course he doesn't have a privilege in the juvenile court, right?
That's it.
My time has expired. Thank you very much.
Thank you, Mr. Smith. Ms.
I'm
Cavan?
not sure you want to either. You get the drift here.
Yeah, I do get the drift. I think that I have to address a couple of things. I think Justice Ireland is correct in his statement that right now, given the statutory scheme, no one has the authority to grant immunity to a witness in the juvenile court proceeding. And when we look at the whole context of the statutory scheme, there's references to testifying in a criminal proceeding, backing up to a question that was raised that is not really before us. A youthful offender proceeding is not a criminal proceeding. When they invoked the youthful offender statute, they were still careful to continue the civil label. So, in fact, even a youthful offender proceeding is not a criminal proceeding. I think Justice Ireland is correct Judge Blitzman did not feel he had the authority, whether we talk about honoring or extending and applying the grant of immunity. If it is transactional immunity and the court comes down on that, then of course it comes back into the juvenile court. But for many people who function in the juvenile court, it raises issues about the distinct forum that the juvenile court is. And it may be that, in fact, practically speaking, immunity has to come back in when it's granted up there. But in this particular case, we have a funny situation because, in fact, the Superior Court trial never occurred. One pled out, the other one's in INS custody. I mean, so the grant of immunity occurred, but there was never testimony in that Superior Court. There was the grant of immunity there. It was a lawful grant of immunity. There is no dispute about that.
What
is-
difference-
yeah.
what difference does
What
that
does
make?
that make? You got immunity, you got immunity. Why does you have to testify?
And you're right, absolutely. I can't argue that one way or another, except to say that there's a concern that, in fact, this would not just occur in YO cases, which are the serious cases. This certainly could occur and involve someone who's a delinquent, could be a 13 or a 14-year-old. And then what do we have? And again, we put
Why
aside-
would that be bad? So what would be wrong?
We have an issue about what do we do with that juvenile, because the legislature has clearly signaled to us that they know how to include DYS sentencing or
But we aren't
confinement in DYS.
immunizing that juvenile, the defendant juvenile, the juvenile against
Not the
whom
defendant, I mean the witness, the witness.
The witness, so-
If he's held in contempt, we can't put him in the House of Correction if he's 13, 14, 15, 16.
We'll put them somewhere. But isn't the whole point, whether the things you're talking about are youthful, civil sorts of proceedings or non-criminal because they're juvenile, isn't the whole point not so much that, it's the Fifth Amendment. Once that's claimed validly in any kind of proceeding that, has sort of quasi-criminal overtones, immunity becomes operative if granted.
Yes, you're absolutely. I cannot argue that. And what I can say is that the juvenile court judge, based on the very specific language that Justice Cordy referred to in Russ R., felt he did not have the authority.
may have to be
and it may
cleaned
be
up a
that
little
this
bit.
is. We have to clarify that.
Right.
But there's no, as I read Lassar, it talks always about the grant of immunity. Lassar does not address the effect once a witness has been granted authority. It says, going to, whatever the impact on the powers of the juvenile court judge as a result, the legislature's made clear that choice, but those powers link back to whether there can be a grant of immunity. And so to some extent I felt that the Commonwealth, and the youthful offenders were like passing like ships in a night. You have to focus on who can grant, and that's why I was having problems with Mr. Curtin's hypothetical down the road about whether the SJC could grant immunity in a grand jury proceeding when it was clear that the testimony was going to take place only in the juvenile court. Okay? So I don't know about that. Maybe yes, maybe no. That's not this case. But the nub of the question seems to me, if there's been a grant of immunity, what happens to that witness who has the full extent of his Article 12 constitutional protections?
And
How do you address the question? I've just raised the same hypothetical with you. He testifies, not this case, but the witness testifies under the grant of immunity in the Superior Court. I saw the knife. There was a knife. Enormous pressure is brought on the witness to testify in the youthful offender proceeding in the juvenile court, and he testifies, I didn't see the knife. He tries to take the Fifth Amendment. He waives the Fifth Amendment. He doesn't take the Fifth Amendment, but can the Commonwealth then come in and prosecute him?
for perjury?
Yes?
Absolutely. They could do that in it. They could do
They
that
could
in
prosecute him for
delinquency.
perjury anyway, because the one thing immunity doesn't grant is immunity against perjury.
Right. So, perjury is perjury, regardless of whether it occurs in the delinquency proceeding, youthful offender proceeding, or an adult criminal proceeding.
Perjury is a new crime.
You know, the reality is that the practical situation here is that the juvenile court needs clarification, the prosecutor's office needs clarification, defendants need clarification, and we need to know clearly, because in reality, we function as if the juvenile court is a very unique forum. We function that way because of the mission of the juvenile court. It's not just about punishment and public safety, it's also about the best interest of the child. And that creates a different environment, it creates a different forum. And we know that the kids testifying in juvenile court are subject to peer pressure that's very different. They have a short-term orientation towards the decisions they make. They're young, they're immature, they're not fully developed. As the Supreme Court said in Roper, they're categorically different than adults. And none of that really protects them. If you're right, if you determine that it is a transactional immunity and it goes into any court in the Commonwealth, then that's it. There's nothing more to say. But if we want to maintain some of that unique characteristics of the juvenile court, which is, I think, what the juvenile court judge was feeling and thinking as he read Russar, that I don't think I have the authority, based on the language in Russar, to extend and apply that grant of immunity in the juvenile court, and I'm not sure it belongs there. And I think that is the state of confusion. You know, are we further eroding that special juvenile court form and the unique characteristics of it?
Thank you, Ms.
Thank you.
Kaman. We'll take a short break.